for German item was second April 134 of 2023.
I have considered here all the points, and I ultimately find that there is no substantial question of non-nullity. पूरा डिटेल आपके जितने भी थे सारे पॉइंट्स को अलग अलग कंसिडर
But in my case, no.
No substantial question of law, hence dismissed.
In my case, no. All the condition of order 41 rule.
Also, case item 15, second April 152 of 2017.
But I'm neither of the clear position.
The report इसमें गलत है कि appear करते हैं तो सर्विस है
हाँ ये जो इस तरह से गलत वापस नहीं लिखते हाँ क्या देख के लिखते हैं आपको समझ आ रही है बात क्या देख के लिखते हैं नोटिस हैज अपीयर्ड थ्रू वकालतनामा यस you have to give written explanation for this. We will not ignore this error. किसी के खिलाफ ex parte order हो जाएगा, order में लिखाएगा that notice has been served, he has appeared through वकालतनामा. इतना बड़ा error कैसे होता है? How long have you been there in the High Court? कितना साल हो गया? सेक्शन में नहीं हाई कोर्ट में कितना महीना 15 इयर्स हो गया इसके पहले कहाँ हाँ अपीयर थ्रू वकालतनामा हमको बताइए कहाँ से देख के लिखे हैं ये प्रीवियस कोई नोटिंग है नोटिस वैलिडली सर्व्ड है अपीयर थ्रू वकालतनामा तो नहीं है ठीक करिए अपने फाइल नोटिंग को ठीक करिए नोटिस इज वैलिडली सर्व्ड आप लिखिए वकालतनामा हटाइए और लिखिए नोटिस इज वैलिडली सर्व्ड हाथ से काट के इनिशियल करिएगा पेज चेंज करने की कोई जरूरत नहीं कराइए इनसे हाँ बताइए तो नोटिस वैलिडली सर्व्ड क्या बताइए क्या है कुछ सब्सटेंशियल क्वेश्चन ऑफ लॉ
yes substantial question of law is order dated 1/10/2025
पढ़िए पढ़िए
yes my lord whether onus lie upon the person my lord may I read the entire order then that will be
वो उसका है ना adoption
yes adoption my lord the order is that appellants are original plaintiffs have lost before both the courts have proceeded on the presumption that since adoption is through registered deed as such presumption lies in favor of the defendant.
That's it.
Learned counsel for the appellant has submitted that both the court below have failed to take into consideration that the defendant has been adopted in the year 1970 while registration of the adoption document has been done in the year 1983 after 13 years. Thus adoption is not through registered deed, rather it is memorandum adoption which has got registered and this has no presumptive right value. This aspect of the matter has not been properly appreciated by both the court below as such onus.
The requirement of adoption has been proved.
No, that is the matter. Our case is that at the time of adoption, even in 1970, he was 20 years.
Any finding?
Yes, my lord. The court is relying upon the deed of adoption, and may I read that finding, my lord, of the.
Yes. Finding of the trial court.
Yes, my lord. Issue number 4 and 5 were jointly decided, my lord. May I read that findings, my lord?
Yes.
My lord, it is page 4 of the trial court judgment. May.
Page.
May I read?
Yes.
PW1 Baldev Yadav deposed in this evidence that he know Munshi Yadav, Gono Mahto and Kusia Matwai. They never adopted Munshi Mahto. Munshi Mahto always reside with her father Dhanraj Mahto, and he never possessed the property of Gono Mahto. He deposed in para 2 of his cross examination that he had heard 5 years ago regarding the matter of taking adoption. PW2 Chandri Devi, who is plaintiff, number 1A, and she stated in his affidavit that she is wife of Lakshman Mahto and she made party after death of Lakshman Mahto. The suit is filed for cancellation of adoption deed. Rupan Mahto and Bihari Mahto are both brother. Gono Mahto is son of Rupan Mahto and plaintiff is heirs of Bihari Mahto. Rupan Mahto died before the survey settlement. As such, all the property was recorded in the name of Bihari Mahto. Heirs of Bihari Mahto possess the property of Gono Mahto because Gono Mahto is issueless. Prior to filing of the plaintiff acknowledged that Dhanraj Mahto and his wife has made a wrong document of adoption of his son. Gono Mahto and Kusia Mahto never adopted any person. Munshi Yadav,
You come to the finding.
Munshi Yadav born in 19.
You come to the finding regarding the age.
Yes. It is para 12, the 13. In one paragraph, the finding has been given. After analyzing the evidence of plaintiff, it is clear that witness number 2 is plaintiff 1A
The
himself.
para number 16, on the basis of above discussion,
Yes.
I find and hold. Ready?
Hold. Prove this case regarding Munshi Yadav was 20 years old at the time of said adoption.
Plaintiff failed.
हाँ,
आप कौन है?
failed.
आप कौन है?
हम plaintiff.
Plaintiff है. You
Yeah.
failed to prove that he was more
As
than
per
20
them,
years.
without
Not as per them. That is the finding
finding
of
of
the
the court.
Yes.
Yes, this is the case, my lord. Finding of the court that I failed. My lord, your lordship may exhibit 1 and 1 by A.
No, we will go only by the question of law frame.
My lord, a question of law because my lord, it
So
was
now your plea that he was more than 20 years
Yes.
has been declined by the learned trial court.
Trial
What about the finding of the
my lord, and
appellate
the
court?
adoption, my lord.
We'll come to that.
Yes.
एक पहले age
Yes, age पर.
appellate court का finding बताइए.
Appellate court para 7.
On this point. पढ़िए कहाँ है finding?
Para 17 में is
Para 17.
decided.
आप पढ़िए.
Para 16 में वो दिया है. Another contention of the appellant plaintiff is that the adoption took place in 1917,
Yes.
but adoption deed registered it so and so after 13 years of the alleged adoption. This long delay has not been explained by the defendant, and therefore the said document in afterthought or manufactured. However, the defendant have proved that the giving and taking ceremony of Munshi Yadav took place in the year 1910. The adoption deed mentioned in detail about giving and taking ceremony and other functions that are organized at the time of adoption. The adoption deed also bears the signature of adoptive father as well as natural parents of the adopted boy. All other witnesses have also proved that adoption deed, and therefore its genuineness cannot be doubted. DW1 Bhuneshwar Mahto so and so are the resident of village Yarjori, and they have stated that in their respective deposition that Munshi Yadav was taken in adoption by Gono and Kusia at the time of adoption. Munshi was aged 10 years. They have further stated that proper adoption ceremony like Katha Puja took place in the auspicious day of so and so. Dhanraj Mahto is natural father of the adoptive boy, and he has stated that he has given his son Ramesh in adoption to Gono, Moto and Kusia, and on the day his son was only 10 years old. After the adoption, the name of Ramesh Yadav was changed to Munshi Yadav. He started living with his adoptive parent. DW3 are further stated that the said adoption was registered deed of so and so, Varun so and so. This witness has proved his signature on the adoption deed and has further stated that Gonu and Kusia, both their thumb impression and the witnesses Karamchand, Puranchand Jha, Sarma Ostha and Nandkishore put their respective signature over it. DW6 Paramanand Jha is the priest who had performed the adoption ceremony on so and so. Chandri Devi has also admitted in para 7 of the cross examination that Purnanand Jha and her family priest. Purnanand Jha is the most important witness in this case. He has stated in the position that he has performed the adoption ceremony on such and such. On the day of Dhanraj Moto had given his 10-year-old son. Ramesh Yadav is the adoption to Gonu Moto and Kusia Moto, and after adoption, the name of the child has been changed to Munshi Yadav, and he started living with his adopted parents. This witness has further stated that on 7/3/1983 the adoption deed was registered, on which he and other witnesses, namely Karamchand Moto and Nandkishore Moto, had put their signature. Dhanraj Moto has also put his signature, while Gono and Kusia Sarvasthal has put their thumb impression. The deed was prepared by deed writer Punanand Thakur. This witness has put the adoption deed, which has been marked as Exhibit A. DW6 has also stated that after death of Gono and Kusia, his adopted son Munshi Yadav performed their last rite. DW7 Munshi Yadav is the respondent himself, and he has also supported the fact of his adoption. Thus, all the material witnesses of the defendant respondent are fully supported the evidence. It is clear that giving and taking of ceremony of Munshi Yadav took place on such and such. The Honorable Court in Lakshmi by
That's right.
Yes.
Every ceremony was performed.
Yes.
The priest who
Yes.
conducted the
Yes.
adoption was also performed.
Lord.
The name was also changed.
Lord, there is only one document proved on behalf of the plaintiff, that is Exhibit 1 and 1.
नहीं नहीं आप सीधा इसमें आइए.
Yes, yes, उसी पर जा रहे हैं.
नहीं,
उसी
whether
मान लीजिए,
Roman
he was
1,
1970 he
whether
was,
the onus lies upon the person who asserts adoption,
Yes.
as the adoption is not through registration. कहाँ
Yeah.
है ऐसा? Yes, the learned court has taken that every ceremony was performed.
Yes, that ceremony I am saying, Lord, that ceremony they are proving, Lord, only one document has been proved on behalf of the plaintiff, that is Exhibit 1.
1 or 2 is not
One,
important.
that shows me, Lord, the name of Munshi Moto, and his father's name is natural father, and the age is 24 years.
देखिए, इस
In
तरह से-
1980, Milord.
इस तरह से नहीं चलता है.
Milord, it is
onus
a public documents which has been proved.
देखिए क्वेश्चन ऑफ लॉ के बियॉन्ड सेकंड अपील में
Yes, yes. A question of law. उसी पर
क्वेश्चन
है.
ऑफ लॉ इज
See,
हु हैज द
our-
ओनस
They
the
have to
person
prove.
see the
Yes.
person who the adoption deed was challenged.
Yes,
The defendants asserted that there was a valid adoption.
yes,
They not and they also adduced evidence that the various ceremonies etc. were performed.
yes.
The trial court recorded a finding that he was 10 years of age at the time of adoption. So,
Milord, the finding of the trial court and the appellate court, ignoring the evidence, Milord, the evidence is clear cut that he was 20 years, Milord, that is public
कौन सा
document.
evidence है?
Exhibit 1 and 1 by 1.
Voter list.
Yes.
Voter list is a public document.
Milord, yes, and it was proved, Milord, properly. And Milord, in that voter list, his father name is the natural father. It was of 1984, and at that time his age is 34. He is 34, and the documents relied by the trial court and all those documents proved by the defendant. Those documents are created after filing of the suit in 2008, 2010 documents. Those documents are subsequent documents. No documents before 1983 has been proved on behalf of the defendant. There is no documents on record on behalf of defendant showing that there was any adoption. Rather, there was a document on behalf of the plaintiff that the father's name is the natural father's name, and the age was 34 at the time of 82, 83, the voter list. And they have not, all those exhibited documents on behalf of defendant, they are of the year I card, voter ID card, UID card, all of 2005, 2008. No documents they have brought on record of before the deed of registration, my lord, 1983. There is no document, not a single sheet of documents, my lord, on record to that establishing his case, my lord. And if adoption was there in 1970, what was the Miller to get it Miller deed executed after 13 years? And that WS written statement of the natural father, the adopted father is there on record, father and mother, who have said that they have never taken adoption to the Munsi Moto. They have given in the written statement.
Who's written statement?
The adopted father, Guno Moto and Kusia.
They expired.
Yeah, after filing of WS. They have expired. After filing of WS, they have expired. Even the natural father died and the adopted father also died after filing of the suit in 1986. It is, Lord. And all those documents which were proved on behalf of the defendant, they are of the year 2008, of the ration card of 2001. All those documents are of, Lord, after filing of the suit. And ignoring that WS, my lord, ignoring the documents proved by them, ignoring the evidence, the learned court relying that presumption is against us, therefore. Para 4 of the appellate court judgment, para 4.
Who were original defendant number 1, 2, 3, 4?
1, 2 was the adopted father, mother. 3, 4 are the natural father, mother.
In the written statement of natural parents, it was said that there was no adoption.
The natural adoptive father. The person who has taken adoption has said that, may I read that written statement? That save and accept what has been actually admitted herein above, named defendants herein, after referred as defendant.
Defendant number 1 and 2 were supporting the plaintiffs.
Yes, they have
Naturally.
given. Yes, that there was no adoption. He has not taken any adoption. Yes, they have said. He has said that it is absolutely false to note that the said defendant was given in adoption by defendant number 3 and 4 on 10/2/1970.
Who was the adopted son?
Adoption defendant number 5, who is now respondent number, sole respondent.
Defendant number 5. He was the
adopted son. And his name, my lord, is saying that Munsi Moto, my lord, they exhibit one. Father's name is, original natural father's name is there on record throughout. Nowhere he has ceased from the family
Defendant number 5 also filed his written statement.
Yes.
What did he say?
They are supporting the stand of 3 and 4 that there was adoption in 1970. I was not at the age of 20 at that time.
Adoption of 1 and they have defendant number 1, 2 and 5 are supporting the plaintiffs.
No, 5, 3, 4 and 5 are supporting, are denying the claim of the plaintiff. 1 and 2 are saying that there was no adoption. I have never taken in adoption to 5.
The plaintiff said that there was no adoption.
Yes.
1 and 2 say that there was no adoption.
Yes.
And defendant number 5 says that he was adopted.
He was adopted. And my lord, what he is saying, the my lord, that as with regard to the deed, these defendants state that it was
Just a moment. Upon death of defendant number 1 and 2,
yes.
Who was substituted?
The plaintiffs are the only legal heirs. Nephew, he was the only legal heirs. That is not in dispute. He was the only legal heirs at that time.
दिखाई दे रहा record है?
Yes, sir. In 1986, he had died. All the 4 persons died in 1986, sometime.
What was their evidence with regard to change of status of the defendant number 5?
Right. That is the Aadhaar card they have brought, the Milord, the those documents I'm saying. The Milord, the voter identity card of Milord of 2003, suit of 1983, the Aadhaar card, the electricity bill of 2008, the BPL card, KYC card, all is of the year 2008, 6, 5. All these are documents are there. No documents before 1983 they have filed, showing that that he was the adopted son of Gono Mahto. There is no documents on that.
And your document is of the year?
Year 1983, 80 and 83.
Which showed that he is
His son of or his natural father, and his age has been shown 31 years.
the defendant number 5 has been examined.
Yes, defendant number 5 has been examined as
Defendant numbers are PW7.
PW7.
DW7.
PW7.
DW.
DW7.
Para number 4 of the title appeal.
Yes.
Para number 4.
However, it appears that defendant number 1, Gono Mahto, and defendant number 2, Tusia Mahto, filed their second written statement on ITNA, in which they backed out from their earlier stand and denied all facts made in their earlier statement filed on in 16/1/1984. In their subsequent written statement, defendant number 1 and 2 have stated they have never adopted defendant number 5. No defendant number 5 is given in adoption by defendant number 3 and 4. The alleged adoption ceremony dated so and so never took place.
So they filed a written statement on 24/8. पहले एक फाइल किया, दोबारा कैसे फाइल?
एक jointly filed हुआ था by all the 5 persons, all the defendants.
So
They have, he has stated in
that's
the,
right.
yes, he has stated in that he has not filed. He has his thumb impression has been obtained by wrong notion. That he has said, my lord, in the written statement. And my lord, the amendment of CPC has come, my lord, subsequently, my lord, in 2002. It is of 1984. It was filed, my lord. The additional written statement, in which he has denied that the joint written statement, he has never filed that written statement. He has denied those facts in his written statement. Neither the evidence of his evidence was on record, my lord, because he died after, my lord, in 1986, and the natural father also died sometime in 1986.
So
Yes.
they were never examined
They were
to support their written statement.
Yes.
उनका examination नहीं हुआ
नहीं
ना?
हुआ.
तो फिर
Written statement is there on
written
record.
statement का क्या ही value?
My lord, the written statement is on record.
Maybe on
Yes.
record.
Yes.
It has got no value.
My lord,
Because
now
they were
from
not
the-
examined.
Yeah, they were not examined. Written
So-
statement, but the evidence is contrary, my lord, to the
Who all deposed in favor of the plaintiff?
the plaintiff themselves, my lord, and the villagers. Only 3 witnesses are there, my lord. Baldev Yadav, Chandri Devi, and Mahar Modi. Only 3 of them are there. And only 1 document has been
The trial court as well as the appellate court,
Yes.
after scrutinizing the records, have come to a finding that adoption was valid. Correct? You say that your document was not considered.
Yes.
That is a voter list.
Yes.
Where is the discussion of that document?
My lord.
Where is the discussion of the document in the judgment?
They have never discussed that judgment. That is our
That
case,
was
my lord, that
exhibit-
after 13 years they got
That
it
was exhibit.
on the basis of
Exhibit number, please.
one by one. The
One by
appellate,
one.
one and one by one.
Okay.
That is-
It was dated.
Yes, that is, you know, it is of 1980. Document is of 1980, and the another one is of 1975. Where it is shown Munshi Yadav, it is as per them the name was changed to Munshi Yadav, son of Dhanraj Yadav. Dhanraj Yadav is the natural father, and age has shown in 1980 31 years. And 75 voter list is, you know, here Munshi Dhanraj Yadav. Even if it is accepted in 70, you know, both these documents, is 26 years.
75 में 26 years.
Yes.
और
And-
1980 में
31 years.
31 years. नहीं, एक second. Exhibit 1.
One and one by one.
Exhibit 1 1980 में 31 years. Exhibit 1 by 1
75 का है 26.
years.
And the father's name is the natural father's name. If he has ceased from his natural father, Lord, then the father's name should have been Gonomoto. Nowhere, everywhere Dhanraj. He is shown along with the table also, Lord, along with the family of Dhanraj. All the family members are of Dhanraj.
You see, on the basis of the judgment passed by the Supreme Court, wherein it was held that a voter list is not a document of proof of date of birth.
Lord.
The judgment of Supreme Court has been taken into consideration, and the learned court holds that entries in voter list, it cannot be on the basis of which it cannot be. So document has been considered.
Yes.
तो आप
But-
कैसे बोल दिए not
but
considered?
The documents on the
आप
basis.
कैसे बोले कि not considered?
Milord, this is my case is that their documents, Milord, all are subsequently created document
आप
considering.
कैसे बोले कि not considered?
Milord, It has not been properly appreciated by saying.
Not, it has been properly appreciated by citing a Supreme Court judgment. You say it is not
Your Lordship
properly
Your Lordship
appreciated.
May please read the entire order. That will
just a
that
moment, we will see. कुछ para 14 पढ़िए तो पूरे पढ़िए. Para 14 of the appellate court judgment. पढ़िए.
Learned counsel for the appellant, plaintiff have submitted that if Munshi Yadav was aged 26 years in 1975, then in 1970, the year of adoption, his age was 21 years. Therefore, he has not eligible for valid adoption as per condition laid down under section 10(4) of the Act. The learned lower court has failed to appreciate this fact, has wrongly dismissed the suit. However, it is well settled that voter list is not authentic proof of age of the person. Therefore, relying upon the voter list to show that Munshi Yadav was more than 21 years of age in 1970 will not only erroneous but also against the settled principles of so and so. The Honorable Court. A voter list is not a document in proof of date of birth. Honorable Supreme Court in Akbar versus so and so has also held that voter list is not decisive in determining the age of a person. Therefore, on the basis of the entries made in voter list, it cannot be held that Munshi Yadav was a major in 1970. Therefore, not eligible of being taken in adoption. The documents and other materials on which such entries are made are not available to the court, and therefore it is not safe to rely upon those entries made in the voter list. Such list and entries also become doubtful when person whose name appears in it himself contests the genuineness. Both Gono Mahto and Kusia Mahto and their adoptive parents and Dhananjay have admitted in their written statement that so and so Munshi Yadav was validly adopted in 1970, and on the at day he was 10 years. The plaintiff appellant have not adduced any legal and reliable evidence to rebut this fact. The plaintiff has
Second appeal number 152 of 2017. Heard the learned counsel for the appellant, as per the office note, in spite of service of notice upon the respondent, nobody has entered appearance. This appeal has been admitted for final hearing by order dated 1/10/2018 on the following substantial question of law. The learned counsel for the appellant has submitted that the suit was filed seeking a declaration that the defendant number 5, namely Munshi Yadav, was never adopted by defendant number 1 and 2, who were the alleged adoptive parents of Munshi Yadav, and nor they were ever given on adoption by defendant number 3 and 4, who were the natural parents of Munshi Yadav. A prayer was also made seeking a declaration that the alleged deed of adoption executed by the defendant first party and second party on 7/3/1983, which was registered at Devar Registry in favor of the defendant number 5, was void, illegal, and a paper transaction. An alternative prayer was also sought that if it will be found that there was, in phase of adoption, the same be cancelled, since the said deed offended the mandatory provision of law, and a permanent injunction was also sought, restraining the defendant number 5 from enforcing any right. A cost of suit was also paid. The learned counsel for the appellant has submitted that defendant number 1 and 2 were the adoptive parents. Defendant number 5 was Munshi Yadav, the adopted son, and defendant number 3 and 4 were the natural parents. It has been recorded in the paragraph 4 of the title suit, judgment of the title suit, that during the pendency of the suit, the defendant number 1 and 2, 1, 2, 3, 4, and plaintiff number 2 died, and their name was deleted on prayer of the plaintiff. He submits that the name was deleted as the legal years were already on record. He further submits that consequently there remained only one plaintiff and one defendant. The learned counsel submits that both the courts have erred in law in not considering the exhibit 1 and 1 by 1 adduced on behalf of the plaintiff, which were the two voter lists of Devghar Assembly. One was prepared in the year 1980 and the other was prepared in the year 1975, in which the age of Munshi Yadav was recorded as 26 years and 31 years respectively, and his parentage was also shown to be son of his natural father. The learned counsel for the appellant has further submitted that the deed of adoption was registered on 7/3/1983, stating that the adoption had taken place way back in the year 1970. The deed was registered after 13 years of the alleged adoption, and on the date of adoption way back in the year 1970, the defendant number 5 was more than 20 years of age. He submits that the deed of adoption cannot be taken as a gospel truth, and accordingly the substantial question of law as framed by this court is fit to be decided in favor of the applicant. After hearing the learned counsel for the appellant, this court finds that the learned trial court, after scrutinizing the materials on record, has recorded a finding that the plaintiff failed to prove his case regarding that Munshi Yadav was 20 years of age at the time of adoption and he was married at that time. The findings in this connection by referring to the materials on record has been mentioned in paragraph. The finding with regard to the age and also the other materials with regard to adoption has been recorded in paragraph 13 to 16 of the trial court's judgment, which is quoted as under. The learned appellate court also considered the materials on record and the exhibit 1 and 1 by 1, which has been referred to by the learned counsel for the appellant, has also been taken care of by paragraph 13 and 14 of the appellate court judgment. The learned appellate court has rejected the reliance, has held that the voter list is not a document in proof of date of birth. And it could not be relied upon to say that Munshi Yadav was major in the year 1970 and therefore not eligible for being taken in adoption. The appellate court the findings of the appellate court in connection with age is in paragraph 13 and 14 of the judgment, which is as under. The learned with regard to the ceremonies of adoption, the learned court as well as the appellate court have scrutinized the materials on record and the findings of the learned appellate court in that connection has been recorded in paragraph 16, wherein the learned appellate court, after scrutinizing the materials, recorded that giving and taking ceremony of Munshiyada took place on 10/2/1970. This court finds that the learned trial court as well as the learned appellate court have scrutinized the material and have recorded findings in connection with compliance of the basic ingredients of adoption and the scrutiny of the, and this court finds that the defendant number three, 4 and 5 asserted that there was a legal and valid adoption in the year 1970 have not only based their case on the basis of registered deed which was registered after 13 years, but have also proved the case of adoption by leading evidence. The specific case of the plaintiff that Munshi Yadav was major on the date of adoption in the year 1970 has been specifically discarded by both the courts by citing reasons and after scrutinizing the materials on record. Therefore, the onus of proving the factum of adoption has been duly proved by the defendant number 3, 4 and by the defendant number 5. And accordingly, this court is of the considered view that the onus having been discharged, the first point of law is fit to be decided, is hereby answered against the appellant and in favor of the respondent. So far as substantial question number 2 is concerned, this court finds that upon scrutinizing the materials, this court finds that both the courts having scrutinized the material and having found that the factum of adoption in the year 1970 was duly proved, and they have not simply relied upon the registration of memo of adoption, and accordingly the second question of law is also answered against the appellant and in favor of the respondent. Both the questions, substantial questions of law, having been answered in favor of against the appellant and in favor of the respondent, there is this second appeal is hereby dismissed. पासओवर तक कहाँ
Passover case item 17, second appeal 169 of 2017.
Mr. T.N. Jha was here. Appellant की तरफ से कौन था? Mr. Chakravarti. Where is Mr. Jha? हाँ Mr. Jha.
have gone through judgment at the second level. That's correct law, provision of law, that principle is decided in correctly. But that principle is not applicable in my case now. Because the trial court has not taken into consideration the real controversy stated in the plaintiff law. And so the appellate court at para 9 law has stated that all the evidence considered by the trial court is not in consonance with the plaintiff law. But in plaintiff law, the case of the plaintiff has not any prayer for declaring the sale deed of the year 1936 law. They are only prayed for declaring illegal the sale deed, registered sale deed of the year 2006. But the learned trial court law
2006 का सेल डीड कहाँ चैलेंज था?
36 का चैलेंज नहीं किया है।
2006 का
2006 का 2006 का चैलेंज
2006
2006 का चैलेंज किया। तो उसमें जो है ट्रायल कोर्ट हैड टेकन स्टैंड that the sale deed is registered of the year 1936 Mula, and that it was unregistered, and therefore all the subsequent sale deed is illegal. That there should have any prayer.
नो ऐसा नहीं है फाइंडिंग
हाँ,
कि ट्रायल कोर्ट का इसलिए फाइंडिंग नहीं है. The reason for giving a finding that the subsequent sale deeds are bad in law, the reason is something else, not because it was unregistered. Is there any finding of the learned trial court that because the deed of 1930 was unregistered, therefore it is not valid?
yes.
Where?
Page 20.
दिखाइए.
Page 20. Page 27 लिखा है ट्रायल कोर्ट में.
दिखाइए. कहाँ कैंसिलेशन ऑफ सेल डीड का पेयर है? वादी का ये केस अपने हक एवं स्वामित्व के उद्घोष के लिए. कहाँ कैंसिलेशन ऑफ सेल डीड का पेयर है?
Length में.
प्लेंट में दिखाइए. दिखाइए सर इसको खोल. प्लेंट में दिखाइए प्रेयर कैंसिलेशन ऑफ सेल डीड.
हाँ. लीफ नंबर 3 लेंथ का पेज 8. Relief number E, that the sale deed number 1285 dated 2006 executed by defendant
seen.
number 1.
यस दैट प्रेयर इज देयर. लेकिन आपके जजमेंट में नहीं लिखा.
Judgment में नहीं लिखा है. Trial court has not considered, not stated the full facts of the case now.
और डिग्री में क्या किया है? आदेश में देखिए क्या है. फाइनल जजमेंट क्या है ट्रायल कोर्ट में? पढ़िए सर।
उपरोक्त किस्सों का विवेचन करने के बाद न्यायालय यह पाती है कि शिवचंद्र नाम का कोई व्यक्ति था ही नहीं, जबकि ये इशू था ही नहीं कि शिवचंद्र है कि नहीं है, ये जो है इनका प्लेंट में है ही नहीं, इनका प्लेंट में नहीं है।
एक सेकंड पढ़िए।
उपरोक्त किस्सों का विवेचन करने के बाद न्यायालय यह पाती है कि शिवचंद्र नाम का कोई व्यक्ति ही नहीं था। प्रतिवादी का निश्चित करने में असमर्थ रहे कि उक्त नाम का कोई व्यक्ति सचमुच में थे, या कुछ देर के लिए मान भी लिया जाए कि शिवचंद्र नाम का व्यक्ति था भी, तो हिंदू सक्सेशन एक्ट की धारा 8 के तहत वह तूफानी साल का भतीजा होने के कारण क्लास 2 के क्रम संख्या 4 में आता। प्रतिवादियों ने यह भी पूरी तरह सिद्ध करने में असमर्थ रहा कि उक्त जमीन कैसे उनको हस्ताक्षर किया गया, इस बाबत उन्होंने कोई कागजात पेश नहीं किया सिवाय सादा केवाला, जिसके शिवचंद्र द्वारा स्वयं को उक्त जमीन का वारिसान बताया, किंतु उस जमीन उसे दान में या दत्तक पुत्र के रूप में या किसी माध्यम से प्राप्त हुआ, इसका कोई वैध दस्तावेज अभिलेख में उपयोग नहीं है। और दूसरी ओर हिंदू सक्सेशन एक्ट के तहत जब व्यक्ति का कोई पुत्र नहीं होता है, उसका संपत्ति उसके परिवार वालों में क्लास 2 में जाता है और क्रम संख्या 1, 2, 3, 4 इतना में वर्ण श्रेणी वालों को चलाया जाता है। इस क्रम में वादी के पिताजी और उनके चाचा छठू साहु क्लास 2 के क्रम में आते हैं। इससे भी स्पष्ट होता है कि उक्त जमीन को शिवचंद्र को किसी भी कीमत पर बेचने का अधिकार नहीं था एवं उक्त सादा कागज VCNT के धारा 4 के विरुद्ध है, इसे रजिस्टर्ड होना आवश्यक है। अर्थात इसी क्रम में जब प्रथम स्वामित्व हस्तांतरण ही अवैध है, तो बाद के हस्तांतरण कैसे वैध हो सकते हैं? एवं चूंकि प्रतिवादी संख्या 1 तस्वीर हसन को जो हक मिला वह भी पूर्व से ही सही नहीं था, अतः उनके द्वारा किया गया बिक्री प्रतिवादी का दूर की तो किया वह भी सही नहीं है।
सेक्शन 17 का तो जिक्र ही नहीं है, लिखा है सेक्शन 4 ऑफ CNT एक्ट में।
नहीं, दूसरी बात
नहीं, दूसरी बात नहीं, पहले सेक्शन
सक्सेशन एक्ट का चर्चा कर रहे हैं। हिंदू सक्सेशन एक्ट 1956 के पहले ही तो कोई प्लेंट में कोई स्टेटमेंट नहीं है कि तूफानी कब मरा, मजहर कब मरा, ये कोई चर्चा नहीं है। हम तो परचेजर, हम तो सब्सिक्वेंट परचेजर, हम तो दूसरे फैमिली के हैं। इनको ये स्टेट करना चाहिए था कि कब कौन मरा, लेकिन फ्रॉम द वेरी फैक्ट स्टेटेड इन प्लेंट इट इन्फर्ड that all they have died before coming to force of 1956, and therefore any pleading with regard to Hindu Succession Act is erroneous. Funding on that
was your entire case based on the execution of a sale deed by शिवचंद्र राम?
शिवचंद्र साहब
इन्होंने कब दिया था, कब ये एग्जीक्यूट किया था?
1936।
ये 1936 का सीन।
हाँ, 1936 का। और इन्हें
एक सेकंड, ये जो फाइंडिंग है कि शिवचंद्र राम नाम का कोई आदमी नहीं था, ठीक है? Was that their case in the plaint?
प्लेंट में नहीं है।
Was any issue framed in that connection?
Yes.
Issue frame है। You joined issues on that.
Yes.
ठीक है? You led evidence on that issue.
Yes.
And ultimately, the learned trial court held that the executor of the sale deed, namely Shivchandra Ram, was never in existence. Correct?
पता है कि था कि नहीं?
अरे भाई,
सर्टेन नहीं है।
फाइंडिंग है ना?
शिवचंद्र नाम का कोई व्यक्ति था ही
नहीं, यही फाइंडिंग।
ये फाइंडिंग। बट
एक सेकंड, बट बाद में पहले ये बताइए कि जब तक ये फाइंडिंग सेटिस्फाइड नहीं हो जाएगा तब तक उस डीड के सब्सिक्वेंट डीड का कोई वैल्यू रहेगा कि नहीं?
इसे सेटिस्फाइड कर दिया है ना। एपीलेट कोर्ट हैज सेटिस्फाइड ऑन perusal of the evidence.
Has the appellate court set aside this finding?
Yes.
With regard to Shivchandra Ram?
Entire finding को entire trial court has taken issue.
Show me the discussion in the appellate court with regard to this finding. दिखाइए आप हमको कहाँ पर इस फाइंडिंग को डील किया है, दिखाइए। ये जो फाइंडिंग रिकॉर्ड कर दिया ट्रायल कोर्ट ने, इस फाइंडिंग को एपेलेट कोर्ट ने कहाँ डील किया?
पारा 9 में
पढ़िए लाइन लाइन, हम लोग तो पढ़ लिए हैं, हमको मिला नहीं, आप पढ़ के बताइए और लाइन नंबर बताइए।
ट्रायल कोर्ट जो फाइंडिंग किया है उसको क्या साबित किया है?
ट्रायल कोर्ट को क्या ही देखना है, आप एपेलेट, आप तो एपेलेट कोर्ट के जजमेंट पे रिलाई कर रहे हैं ना।
उनका फाइंडिंग जो है नो एविडेंस है, और नो एविडेंस, कोई आधार नहीं है उनको फाइंडिंग देने का। उसको
ऐसा कोई फाइंडिंग एपेलेट कोर्ट ने लिखा है कि इस फाइंडिंग को देने का कोई आधार नहीं था?
कंसीडरेशन ऑफ एविडेंस
ऐसा कहाँ लिखा है एपेलेट कोर्ट में?
आफ्टर हैविंग हर्ड,
नहीं, आप अपने से पढ़िए और हमको खाली वो पोर्शन बताइए। हम लोग तो 2-3 बार पढ़ लिए हैं, आप पढ़ के बताइए।
consistent with the case as seen in the unit examination. They have developed legal understanding of the social people also felt to merit even boundary.
Lordship, kindly, for the moment, Lordship.
Decided it was not proper to have approved the civil court. This is the immediate admission that they are not advanced position of the dispute clear. Advance to the state that they will put in litigation transfer in line with their plans by way of responsibility which is genuine to me. It was incumbent upon that this document should have been conceived by the court unless the responsibility is conceived. It always cast shadow of about the right item of the contested party. Commission to the name of the order so that should be referred to the court first secondly. Without having considered which is determined and without having some necessary information to the start, do not reckon possible to declare the right item of position of plenty in any manner. And hence enhancing the right position corresponding to that plan or false entry incorporated in the then burden was cast upon them to prove it had no force. Further, the plan had not forced that any say which is not to be registered. It is admitted that since long the responsible was in persuasion, then it was cast upon the son of the responsibility relating to although do not confer right at all, situation of the student by continuous civil law in favor of real Islams that SLC be unity in Nigeria are distinctly between the brain but also between them. This is also burden of the respondent. It is, however, they immediately can disregard the recital of the case was that it is full for consideration and man has got no step member has got continuous right and without any interference, say this document was duly registered after paying required stamp duty. Therefore, there is a strong presumption of the favor of law. The uninterrupted position since 1936 to 2006 do not be allowed to be disturbed merely on legal grounds but it also be for plenty. They have learned manage and got their position and most in the market by practicing unfair means. Even the burden was also upon him to establish a manner fraud was done. If any entry were managed, in fact, weekly revenue records are the best proof of so. Real situation and there is presumption in the characteristic limited by prepared evidence. There is also meeting suppressed relevant documents as the real legislation which entry have been present in the you are appellate in exact words as it is written in the remand, but consider the circumstances, the available materials on the record below, so many rent receipts and entries in the revenue record, all the shows that the Sadat sale deed of the year 1936 executed by so-called Simchand Shah was recognized, and that fact has also been admitted and plaintiff also below that in Jharkhand.
Therefore, see, the appellate court has independently considered all the materials
Well,
and come to a finding. But the appellate court, while reversing the decree and coming to a different finding, whatever was recorded by the learned trial court has not dealt with the judgment of the learned trial court while reversing the decree.
reasoning
बोलते
has- the reasoning
अरे भाई
has been-
आपको समझ ही नहीं आता बात.
आप तो बोल रहे कि जो reasoning होता है,
Trial court has given reason number 1 to pass a judgment. Appellate court has given reason number 2 to pass a judgment. But appellate court has not considered as to why the reason number 1 was incorrect. आपको वो जजमेंट पढ़े, उसमें लिखा है ना कि रीजन को मीट करना होगा. कहाँ मीट किए हैं?
स्पेसिफिक वर्ड नहीं दिया गया,
स्पेसिफिक कुछ भी नहीं मीट किए हैं. एक लाइन आप हमको दिखाइए,
लेकिन उनका
एक लाइन आप दिखाइए एपीलेट कोर्ट का जजमेंट में कि देयर आर फाइंडिंग्स अराइव्ड एट बाय द लर्नेड ट्रायल कोर्ट इज इनकरेक्ट. दिखाइए. है ही नहीं. इसीलिए उसको मैटर को रिमांड ही करना पड़ेगा. वी डोंट हैव एनी ऑप्शन. और उसके बाद आप अपना प्लेंट, रिटन स्टेटमेंट, रेस्पेक्टिव केस का पार्टीज का जो भी केसेस था आप अपना बहस करिए वहाँ. लेकिन appellate court has not dealt with the reasons assigned by the learned appellate court, by the trial court to decree the suit. नहीं है ना भाई. सबमिशन तो आपका रहेगा ही. आप वकील की तरह नहीं, लिटिगेंट की तरह सबमिशन मत करिए. 2 अप्रैल में वकील की तरह सबमिशन करिए. और अगर सबमिशन कर रहे हैं ऑर्डर से दिखाइए. ऐसा बेयर सबमिशन से नहीं चलेगा कि ऑर्डर ठीक है. अगर आप सबमिशन कर रहे हैं सब्सटेंशिएट करिए ऑर्डर से.
Also taken notice of section 87 that admitted case that matter is pending before the revenue court. Then how the suit is maintainable? And 1936 का सेल डीड को जो जिसको कि रिलाइड अपॉन किया गया subsequent and all the authorities has accepted it correct law. I challenged in the year 2006 law. Without considering the point of limitation, trial court should have gone through the details of the case law. ताकि इसमें जो है सो स्पेसिफिक बाय वर्ड नहीं लिखा है, लेकिन सर्कमस्टांस कंसीडरेशन ने पर ने जो सर्कमस्टांस दिखाया है that is sufficient to meet the reasons of the trial. इनका अपना केस है कि इनका इंसेस्टर के नाम से कभी कोई रेवेन्यू रिकॉर्ड में नाम ही नहीं हुआ.
नहीं है.
Yes, by हिंदू सक्सेशन एक्ट का ही प्ली लेता है. 1940 में कहता है कि हम लोग बंटवारा किए, बंटवारा तो उसी साल से ही मरे थे. उस समय में हिंदू सक्सेशन एक्ट कहाँ है?
हम लोग का प्लीडिंग यही था. शिवचंद्र नाम का कोई आदमी नहीं है.
हम लोग
और लॉर्डशिप
गुजरात प्रोसीडिंग चल रहा
हिंदू
था.
साहब का 2 बेटा था जिसमें
उसमें कोई ऑब्जेक्शन नहीं हुआ.
मजूर साहब
उसके बाद उसके नाम से रसीद कर
पानी
दिया गया, उसमें कोई ऑब्जेक्शन नहीं हुआ.
छोटू साहब हैविंग 3
उसके
sons.
बाद 70 साल के बाद जो है 70 साल के बाद जो है सो कहते हैं कि उसका बेटा नहीं था, जबकि अपना एविडेंस में प्लेंटिफ एडमिट किया है कि उनका बेटा मर गया, तो फिर कैसे कहें इशूलेस मरा? प्लेन पे है कि इशूलेस मरा? एडमिशन डिपोजिशन में कहते हैं कि तूफानी का मजहर का बेटा था, मर गया, तो ये कंट्राडिक्टरी हो गया ना।
एविडेंस में बोला है।
एविडेंस में बोला है, आगे तक है। इसको ट्रायल कोर्ट नहीं लिया।
ट्रायल कोर्ट के पेज नंबर 2 में आइए। Kendu Sahu was the recorded tenant. Kendu Sahu.
No. Kedus was father of recorded at Tufani Sahu.
Okay. Tufani Sahu was the recorded tenant. ये just a moment. ये पेज नंबर 2 में आइए, इंटरनल पेज। इनका यही जीनोलॉजी था, जिसमें they claimed that Tufani Sahu had died issueless.
हाँ, उसको हम WS में जो है डिनाई किया है और अपना हम दिया है WS जेनिकोलॉजिकल, जिसमें कि दिखाया गया और वो अपना गवाही में भी जो प्लेंटिफ जो है एक्सेप्ट किया है।
वासुदेव साहु है प्लेंटिफ। वासुदेव साहु ने कहीं ऐसा नहीं बोला है। कहाँ बोला है भाई? 34, 35, 36 में आइए ना, क्रॉस में पैरा 6। उनके मेजर साहु, तूफानी साहु की संतान मर गए हैं, मात्र मेरे दादा छट्टू साहु जीवित थे, जो हिंदू कानून के तहत तकरारी जमीन के रैयत हुए और दखल कब्जा में आए।
In the judgment passed by the learned appellate court, none of the findings recorded by the learned trial court has been reversed. किसी finding को reverse नहीं किया. There are some findings of the learned trial court. None of the findings have been reversed by the learned appellate. The appellate court said that real controversy is something else, and has completely decided the case in his own manner by forming the real controversy between the parties and completely ignored the issues which were framed by the court on which the parties had laid evidence. Correct? ऐसे थोड़ी होता है. देखिए, essay number 169 of 2017. Mr. Chakravarti, if the issue number 2 is decided, then issue number 1 need not be entered into, because the appeal will be decided afresh.
Yes.
Right?
In entire appeal may be decided
Yes,
afresh.
yes. Entire appeal, because these maybe that point of determination has to be framed after, with the assistance of the parties. The findings which have been recorded by the learned trial court,
That should be
that has to be addressed.
addressed elaborately.
Maybe they find that it is fit to be set aside, but that has to be set aside.
Not-
And then only the court can come to a conclusion that yes, the real issue is this, and therefore it is the decision. But without discussing those findings recorded by the learned trial court, they could not have simply set aside the judgment. Essay number 169 of 2017 heard the learned counsel appearing on behalf of the parties. This appeal was admitted by the order dated 11/9/2018 on the following substantial questions of law. The learned counsel for the appellant has submitted that if issue number Roman 2, if the substantial question number Roman 2 is decided in favor of the appellant, then under such circumstances the matter has to be remitted back to the learned appellate court for fresh decision. He has submitted that the impugned order of the appellate court is a judgment of reversal, and the perusal of the judgment revealed that the findings recorded by the learned trial court has neither been reversed nor been discussed by the learned appellate court. He has also submitted that even the reasons given by the learned trial court has not been discussed by the learned appellate court. Rather, the learned appellate court was of the view that the real controversy between the parties was something else. The learned counsel has also submitted that even if that be so, the findings recorded by the learned trial court on the various issues framed by the learned trial court was required to be addressed and considered by the learned appellate court. If the findings were not reversed, then the decree also could not have been reversed. यही है आपका. He has submitted that if the substantial question number 2 is decided by way of remand, then there is no need to go into issue number 1, as that will be essentially on the merits of the case. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the learned appellate court has considered the real controversy between the parties, discussed the materials on record, and has reversed the decree. He has submitted that since the learned trial court was completely misdirected in its approach as recorded by the learned appellate court, there was no need to further discuss the findings recorded by the learned trial court. The learned appellate court has applied independent mind on the various materials placed on record and has come to a definite finding. He has submitted that he has also submitted that the sale deed of the year 1936 was not hit by the provisions of section 17 of the Registration Act 1908, inasmuch as the property was valued less than rupees 100. He has also submitted that the subsequent transfers cannot be said to be illegal. The Learned Counsel has submitted that the Learned Trial Court has applied the provisions of Hindu Succession Act 1956, although the transactions were relating to period prior to 1956. The Learned Counsel has also submitted that the petition under Section 87 of the Chotanagpur Tenancy Act was pending, and which was essentially in connection with dispute regarding entry made in the record of rights, and therefore the Learned Trial Court was not justified in recording the findings. The Learned Counsel submits that the appellate court has entered into the real controversy between the parties and has reversed the decree. Both the he has also submitted that the provision of Order 41, Rule 31 to 34 of CPC has been duly followed, and therefore both the substantial questions of law are to be answered in favor of the respondents, and the appeal is going to be dismissed. यही आपका case. After hearing the Learned Counsel's appearing on behalf of the parties, this court finds that the suit was filed seeking a declaration of title of the plaintiff over the suit premises and possession of the plaintiff over the premise of the suit property be confirmed. A further relief was prayed seeking a direction upon the defendant to remove the encroachment and unauthorized construction over the suit property, and plaintiff be put in possession through process of law. A prayer was also made for appointment of a legal commissioner for demarcation of the suit land. A further prayer was made that the sale deed number 1285 dated 3/7/2006 executed by the defendant number 1 in favor of defendant number 2 and 3 for the suit land be cancelled, and a copy of the judgment be sent to Sub-Registrar Latehar for information and need. As per the suit, the land was recorded in the name of one Tufani Sao, who expired issueless. He had full brothers, namely Mujar Sao, who also died issueless, and Chatto Sao, who had 3 sons, namely Damri Sao, Hari Sao, and Padesha Sao. It was further case that there was a partition and memorandum of, and it was recorded in the memorandum of partition dated 4/4/1940, and by that the suit plot was allotted to Polesha Sao and he was put in possession. Therefore, Damro Sao and Hari Sao were not made party in the suit. It was further case that Khatiyan was prepared in the name of Kaleshwar Sao, son of Chattu Sao, Ramlakhan Sao, son of Hari Sao, Ramchandra Sao, Saroj Sao, son of Damri Sao. And in the remark column, it was falsely recorded in the possession of defendant number 1, against which one revenue suit number 2558 of 1992 of under section 87 of CNT Act was filed, and it was pending. It was the further case that Ramchandra Sao was not the legal heir of the recorded tenant, and he had no right to transfer the suit. And as per the provisions of Rule 4 of the Chotanagpur Tenancy Act, no transfer of Rayati land is valid unless the transfer is by registered document. In the aforesaid background, the suit was filed. A written statement was filed on behalf of defendant number 1, 2, and 3, who claimed that the suit was not maintainable, it was barred by law, barred by limitation, and a different genealogy was mentioned in the written statement, in which Shivchandra Sao was shown son of Majhar Sao, and Majhar Sao was shown as brother of Tufani Sao, the recorded tenant, who was said to have died issueless. The second brother of Tufani Sao was named as Chattu Sao, and further genealogy was given. It was the case of the defendant that Majhar Sao died issueless, and he had one son, namely Shivchandra Sao, who inherited the suit property after death of the recorded tenant Tufani Sao and was in peaceful possession of the property. It was their further case that plaintiff had no right, title, interest and possession over the suit land, and the suit land was transferred by Ram Prasad Sao in the year 1936, which was within the knowledge of Chattu Sao. And Chattosaw never challenged the sale deed executed by Ram Prasad Sao, nor the plaintiff challenged the sale deed. And the defendant were coming in possession of the suit property since 1936 and had perfected their right title and adverse possession, and also claimed adverse possession. The learned trial court framed the following issues for consideration. Page number 5 है internal page 5. And one of the issues was as to whether, issue number 5 was as to whether Majar Sao died issueless or he had a son, namely Shivchandra Sao. And issue number 6 was as to whether Shivchandra Sao has duly sold the property to Ram Prasad Sao. This court finds that the learned trial court considered all the issues and scrutinized the materials on record and came to a conclusion by deciding issue number 5 by deciding issue number 5, 6, 7 and 8 that the claim of the defendants with respect to the property was illegal right from beginning, as the suit land was not transferred, not duly transferred by the owner of the suit land, and with the passage of time the same cannot be, the error cannot be rectified. The initial illegality cannot be rectified, and held that the initial sale itself was illegal, and therefore the subsequent sale was also illegal. The learned trial court also recorded a finding in the final order that there was no person, namely Sivchan Ram, and also referred to certain provisions of Hindu Succession Act, and also recorded that the transfer was against the provisions of Rule 4 of the Sujanakpur Tenancy Act, which provides that the sale is required to be registered. So far as the appellate court is concerned, the appellate court was of the view that the appellate court recorded the case of respective parties in paragraph of the appellant in paragraph 7 and the respondents in paragraph 8. The appellants had challenged the findings recorded by the learned trial court while deciding issue number 5, 6, 7 and 8, and made submissions in that regard. But the learned appellate court was of the view that the appellate court did not record any finding in connection with issue number 5, 6, 7 and 8. Rather, in paragraph 9, the appellate court was of the view that the actual controversy in the appeal was that preliminary issue that whether finding recorded by the court below without having cancelled the sale deed in question was justified in holding that since the initial transfer was bad, subsequent transfer could not be upheld. And that the trial court was, and the rather this shall be illegal. The learned appellate court referred to the various material and was of the and decided the case by observing that there was a strong presumption with regard to the registered sale deed of the year 1936, and there was uninterrupted possession of the defendants, and ultimately held that the trial court was misdirected from the real controversy and committed grave error in ignoring registered sale deed without having cancelled the same. It was not justified in holding that the suit to be decreed was to be decreed in favor of the plaintiff. And in the final order, the learned appellate court simply reversed the findings of the learned trial court and dismissed the suit. This court finds that the learned appellate court has not discussed the reasonings given by the learned trial court, wherein the learned trial court held that that there was no person called Sifchan Ram and also held that the initial transfer itself was not in accordance with law. The learned trial court had also recorded that nobody had seen or known Sifchan as son of Majhar Singh. This court is of the considered view that the learned appellate court, while reversing the decree, has not decided the appeal in accordance with the provisions of Order 41, Rule 31 of CPC. आपकी तरफ से लिखा दे वो judgment. आपको the learned counsel for the appellant has referred to the judgment passed by this court in क्या number है? Second appeal number?
Second appeal number 28 of 2017
28 of 2017.
by an order dated 2/1/2020.
And this court, upon going through the state judgment, which is based on earlier judgments of Honorable Supreme Court and High Court, has recorded that the appellate court, while reversing the decree, is under legal obligation to deal with the findings and reasons given by the trial court. This court finds that the reasons given by the trial court and the findings thereunder have not been discussed by the learned appellate court, and the learned appellate court by one line has simply reversed the decree, reversed the findings in the operative portion of the appellate court's judgment. On view of the fact that accordingly the second substantial question of law is answered in favor of the appellant and against the respondent, and it is held that the learned appellate court has illegally reversed the judgment and decree of the trial court without meeting with the reasons assigned by the trial court and has acted beyond the scope of Order 41, Rule 31 to 34 of Code of Civil Procedure. The issue number one, in view of the aforesaid judgment, the matter is required to be remanded to the learned first appellate court for fresh decision in accordance with law. So far as the substantial question number one is concerned, the same is touching upon the merits of the case, and since the matter is being remanded to the learned first appellate court, this court is of the view that the same need not be answered by this court at this stage, as the entire first appeal is to be decided afresh. This court is also of the view that the learned first appellate court would, in order to ensure that the point of determination are duly framed and considered by the learned appellate court, it will be open to the parties to assist the learned lower appellate court in framing the point of determination. The appellate court is, the judgment passed by the appellate court is set aside, and the matter is remitted back to the learned appellate court for fresh decision. उसी तरह का कर देंगे, एक तो डेट फिक्स कर देंगे appearance. The parties to appear before the learned lower appellate court by filing fresh file. Considering the fact that the suit is of the year,
Suit is of the year, Lordship, 19. नहीं. Suit of the year, just
2007. 2007. The learned appellate court is directed to expedite the hearing, the parties to cooperate. I disposed of my proceedings. ये दूसरे केस का है, ये इसी का है। ये वाला उस केस से रह गया यहाँ पर, वो जो फर्स्ट हाफ में जो किए हैं ना ऑर्डर, हाँ उसी में डालना है। तो हम लोग कब जजमेंट के लिए पे मंडे को, हाँ उस केस का।
There was a case fixed in 215 serial.
We will take it up. You just hold on. Orders तुरंत ही सुनते हैं। हाँ बताइए।
From date list for orders, item 1, first appeal 451 of 2018.
Yes.
But in all these cases, the litigation petition has been filed, but that has not been served to us. They should be given the copy so that I can file a reply with
बिना सर्व के
the
कैसे?
delay of 1500 and odd days.
1400 days and the copies are already been served.
No, it has not been served. I have been informed. No, it has not been served.
After rejoinder we file on condonation of delay.
I don't know, but I have been informed that the
No,
copy.
आपका इंफॉर्मेशन रिकॉर्ड से मैच नहीं कर रहा। आपने एक रिजॉइंडर फाइल हुआ है ऑफ रेस्पोंडेंट नंबर 1 ऑन बिहाफ ऑफ रेस्पोंडेंट नंबर 1 यूनियन ऑफ इंडिया टू आईए फॉर condonation of delay in filing the appeal.
I will collect the matter.
क्या ही बोले हम? Through Mr.
Pratyush Kumar.
हाँ प्रत्युष कुमार. Yes.
The other cases, I have to verify.
तो तो आप वेरीफाई करिए भैया, ऐसे कैसे आप बोलते हैं? देखिए
लेकिन
Facts
जैसे
of all
नहीं
the cases
लिखेंगे
are
कुछ
there.
नहीं, आप पहले आप तक किसी को लगाइए
दिया
और
हुआ है,
दूसरे में भी
जवाब दिया हुआ है. Then I will collect my notes over the documents are concerned and I will argue on that. Because I had no, neither the limitation petition nor the rejoinder was with me.
आपके पास रिजॉइंडर की कॉपी है?
To see my lord. Today I only brought the limitation petition.
बताइए, ये इनके पास भी कॉपी नहीं है, हम क्या ही कर सकते हैं? आप नहीं, हमको एक बात समझ नहीं आता है मिस्टर
I have been
कुमार।
informed in fact.
सुबह से
yesterday-
ये सारे मैटर्स का फाइल यहाँ रखा हुआ है।
No, Lord, in fact, yesterday I was going through the file, Lord, and I found that there was nothing on record
ये
except
बात
the.
सही है, लेकिन आपके जो जूनियर काउंसिल है उनका काम नहीं है फाइल देखने का। Who will do this? कौन है आपके इसमें जूनियर काउंसिल इसमें? Who is the your junior counsel in this case? You are a designated senior advocate also.
जी अभी हम आए थे, उन्होंने बोला कि आइए फाइल किया हुआ है फॉर द अदर साइट्स। अभी जस्ट हम पूछ के गए।
अगर हमारे कोर्ट मास्टर के कहने से ही सारे केसेस डिसाइड हो जाते हैं तो आप किस लिए हैं?
हम सारे लोग से पढ़
छोड़ दीजिए, कोई बात नहीं, इससे कोई मतलब नहीं। आपको रिकॉर्ड मना किया है उन्होंने? मना नहीं किया है ना? हाँ तो बस फिर आप ये मत बताइए उन्होंने बोला और इन्होंने बोला। आप देखिए बैठकर, हम लोग इसको देखेंगे, 20 मिनट बाद देखेंगे। आप सारा रिकॉर्ड दे दीजिए उनको, सारा रिकॉर्ड।
Tomorrow also 14 cases have been listed. Same batch.
इसी बैच का टुमारो भी है।
Tomorrow भी
चलिए कल कर दीजिए, पूरा बैच उठा के कल कर दीजिए। Learned counsel for the parties are present. Learned ASDI submits that he has to verify the records. Yeah, it is submitted that another batch of matters arising out of the same land acquisition proceedings is listed tomorrow. Post these cases tomorrow. अभी चेक कर लीजिए, एक फाइल सब उनको दे दीजिए चेक करने के लिए।
From supplementary list item 3, 2nd April 19 of 119.
Yes. What are the questions of law framed?
Yes.
बताइए, ये हियरिंग में है ना मैटर?
Here.
क्वेश्चन ऑफ लॉ।
Order number 5, Your Lordship may see 31/3/2022.
Yes.
So, Your Lordship, I'll just start and then it may be carried on.
आज एक केस हम पढ़े थे, लैंडलॉर्ड टेनेंट रिलेशनशिप का, यही है क्या?
ये नहीं, ये this was never heard.
हाँ, नहीं, हम तो पढ़े ना।
अच्छा, पढ़े हैं.
हाँ, पूरा पढ़े हैं,
ठीक.
टोटल पढ़े हैं,
ठीक.
कवर टू कवर।
हाँ, तब ठीक.
बताइए।
So, Your Lordship, the questions of law first I'm reading, that on whether certified copy of registered SEBI, now the plaintiff's case was, I'm not reading that. The plaintiff's case was that the original owner was some Bhagwati Prasad Parsuramka, and then the defendant took the premises on lease from his vendor, and then the same person, he transferred the property to the plaintiff here. This was the case, and then therefore he said that he filed a suit for eviction against him. So during the entire trial,
Give us 4 dates. What was the date of the lease deed?
date of,
Lease.
yes, it was 1/11/1996,
1/11/1996. For a period of
15 years.
15 years. It expired on
30/10/2011.
30/10/2011. It has a renewal clause. It had a renewal clause.
I'll have to.
Okay. Anyways,
I have not verified.
what is the date on which the property was transferred? 2008.
2008.
Correct?
Yes.
2008 property transfer. The deed of transfer was not exhibited.
The deed of transfer was
Exhibited on the date of transfer.
On the day.
in connection with which some of the
Questions
issues-
of law have been
questions
raised.
of law.
Yes.
Now you want to avoid the deed of transfer, or you want to
No, it's not a question of avoiding. Now, at best, what would happen? If my lessor, if he or she had transferred the property, so he or she, the transferee would at best become my landlord.
That's
I'll not become the landlord of the property.
certain.
So I'll remain a tenant
Tenant.
either under the original landlord or under the transferee landlord.
Fair enough.
So the only problem is that your Lordship would recollect that one of the question of law is that it was exhibited on the date of judgment. So why then there is a procedure, there are several rounds of procedure which have been prescribed in CPC for producing the document.
Let us take it
Yes.
that was illegally taken. Let us take it for a moment. If it was illegally taken, then that particular sale deed by itself cannot be relied upon for anything. Right?
Yes.
Now, if there is evidence to show that you have given rent to the subsequent purchaser,
I have not given rent to
that
subsequent.
is a finding. There is a finding that you have given rent to the subsequent purchaser. Once you give rent to the subsequent purchaser, matter ends.
Ends as regards what proportion of the property, the total suit property was 34 decibel.
Therefore, I am saying
Yes,
the total suit property was 34 decibel.
34 decibel.
The area of the suit property comes in light only by virtue of the exhibited sale deed,
Yes,
which you are objecting.
yes.
Otherwise, everything stands admitted
So if the
in the plain and
transferee,
written statement.
the rent receipt would not show as to how, for what is the total area for which I was paying the
Just a
rent.
moment.
Yes.
There was a landlord-tenant relationship for X property, X area. The only dispute which was raised by you was that you don't have any relationship with the subsequent purchaser. There was no dispute in connection with the schedule of the property. Now, with respect to the property which you were in possession by virtue of tenancy, you paid rent to the landlord.
I have not paid rent to the subsequent purchaser
You
as
have.
regards the entire property.
You have. There is a finding. One exhibit 3 was there, correct?
Yes, and 2008 to 10 they have paid.
Therefore, the
And then
date, the
stopped.
date of transfer is 2008. 2008 to 10 you paid, and to them, and thereafter received. And that particular document regarding payment of rent has been exhibited.
So payment of rent, does it show that it was only with regard to 29 decimal or
It
34
will not show
decimal?
anything because the
Now,
exhibit, the exhibit which you are objecting, that is the
No,
sale
no,
deed.
let us
Is there any other material
No.
apart from that sale deed?
let us assume that he was my landlord. He would only be a landlord with regard to the proper portion he has purchased it from my erstwhile landlord.
Show me any material from the record apart from that sale deed which you are objecting to, that he had purchased only a portion of it, either in the pleadings
He
or
himself
in the
says
no.
because he himself does not produce the document which he was required to produce at the time of
So
filing of claim.
that's right. Therefore, you
Then-
are objecting to that document. If that document was wrongly taken into record, then that document will not be seen into for any purpose. You can't have that document for the purposes of saying that it was only portion of the property he had purchased, and at the same time you say that this was wrongly exhibited. You
He
can't have it
himself-
both ways. If it goes completely. And apart from that, show me any material from the record that the property which he purchased was only a portion of the tenanted premises. Sure.
Because I'll just why I say it
सोच
was-
के बताइए.
हम सोच के
सोच के.
अब सोच के बता रहे हैं.
सोच के.
He mentions it very specifically. The plaintiff himself mentions that this is the deed number by which deed date and deed number I have purchased the property. And that is ultimately he produces at
That
the time of
that is
death.
mentioned in the schedule.
He does not even whisper a single word that apart from this sale deed there is another sale deed.
No, he
He does not say so.
He does not.
So if he says that I have purchased the property from erstwhile owner and this is the sale deed number, this is the sale deed date, which ultimately turns out to be only 29 decimals.
Therefore, I
then
want
what
to
would
say
happen?
whether you want to rely upon that sale deed or you are objecting to exhibiting of that sale deed. By
I
saying
say-
that it was not properly, you can't have it both ways. That it was wrongly exhibited
No.
and at the same time
Why,
rely upon that.
why I am objecting? My only concern
your
is
objection is sustained.
no.
Yes, it was wrongly exhibited.
Why I am objecting that answer? Your Lordship, if he would have produced it at the time when the CPC lays down that he has to produce it, a copy of which has to be produced along with the plaint, then second round comes when the issues, before issues, he has to produce the original document. He does not produce. So if he would have produced, then I would have laid evidence to show that this was only related to a particular portion of the land. That is all.
That is okay.
I could not have said that I have become the owner of the entire.
Let us assume that what is the consequence of non-production of that document. Let us exclude that document
No,
completely.
I cannot deny a registered instrument. The
So
manner in which I was not allowed
so you
to
want to
contest.
give up all this? Issue number 1?
I only say that if it would have been produced earlier, then I would have an opportunity to show that the suit property was actually 34 and the prayer which he was making was only with regard to a property. This was the only reason. Otherwise, I cannot deny a registered transfer.
Now, there is evidence that you paid rent for the entire premises to this defendant.
That also, that I have not got.
And once there is evidence to that effect, you are absolutely precluded from arguing that there was no landlord-tenant relationship.
So if it was for entire premises,
Yes, it is.
Then I'll verify. I'm certain that it is not.
And Mr. Counsel, you did not produce the sale deed at the threshold because you knew that it is not for the entire tenant. Correct? There is no explanation for non-production of the sale deed.
The certified copy was not available that time.
Okay, very fine, very well. If we take that sale deed into consideration, the entire property is not covered.
There's only a one-line finding in the appellate court's order that it mentions the schedule
No, it
with
is,
the
we have
codes.
seen that. We have seen the document also. There is one plot number which is completely missing.
One of the documents. It mentions the with the old structure.
That's right. One plot number is completely missing in the sale deed. So under such circumstances, this particular sale deed having been exhibited on the date of the judgment, was the appellant not prejudiced?
So should the appellant always knew that the basis of the claim is the sale because the previous
That's right.
landlord
But
had
who was-
informed in
Who
writing?
was required to produce the sale deed?
It had to be produced by the
Plaintiff.
By the plaintiff, yes.
You did not produce it.
It was produced at a late stage.
If it was produced at an appropriate stage, then under such circumstances, they would have had an opportunity to question the eviction of the entire premises. So,
At best, they could have said that apart from those 10 decimals, at least it is only a question of those 10 decimals.
so therefore, eviction to the extent of 21.95 is only to be sustained, and nothing more. That will require a measurement and an eviction. We do not know. Because you are not the owner of the entire property. How the entire property can be handed over to you? Do you have any other sale deed?
There is no other sale deed. This is the only sale deed. The only difference is that the previous landlord mentions that I have sold the whole property. They are related, uncle and nephew. It was sold within the family by the
Previous landlord never deposed.
previous landlord did not depose, but he wrote a letter which is exhibit.
लेटर से वो उसका उनका
To
लेटर आप
the
एग्जिबिट
tenant.
करेंगे कि उनको खुद ही आके एग्जिबिट करना था?
No, it was admitted on evidence on admission. The cross examination, the DW2 Vinay Dokania
अब
had
सुनिए कहानी, अब हमको बताइए क्या करना है? Tell us how this situation is to be resolved. अब एडवोकेट की तरफ
नहीं, advocate नहीं. This is actually serious. Now your lordship may see these circumstances. I'm not talking
we
about.
appreciate that it is very serious.
I'm-
जिस दिन जजमेंट है उस दिन एक
नहीं,
डॉक्यूमेंट लाके
इसी के
एग्जिबिट
लिए हम बोल
एंड
रहे हैं।
that document has been marked as exhibit without objection. Although there was an objection.
How would a defendant get an opportunity to object when
Yes.
it has been fixed for judgment and he accepts it
Not at all,
and marks it?
not at all proper, not at all proper.
And when we raise this ground before the appellate court that please look into it was marked on the date of judgment and it was accepted and whatever and it only relates to a particular portion of land suit property, not the entire. The appellate court does not even care to discuss that portion of my. It was required to discuss that.
So you say that at best you could have been evicted only with respect to portion of the property.
Only with a portion, but they have to establish which portion out of 30.
No, it is
How?
no. I'll tell you. The property in connection with one plot number is missing. That plot number is completely missing. So it can be easily ascertained. There is no difficulty in ascertaining. आप देखिए आप सूट लैंड में जो 3 प्लॉट नंबर है ना, उसमें से एक प्लॉट नंबर मिसिंग है इनके सेल डीड। Exhibit 6,
324B, 325B, 326B.
326B is missing.
0.06.
Yes, 326B is missing in the sale deed. 324 and 325 ही हैं. 326 is missing. दिखाइए तो जरा, ये दिखाइए जरा हमको। ये सेल डीड का शेड्यूल देखिए। Mr. Rahul, I will look at that. $326 is completely missing.
What problem is there? Your lordship, this is the sale deed. This is the sale deed and
Please wait, sir, see sometime.
now your lordship may kindly compare the suit property and the sale deed. Sale deed says out of 324B measuring an area of 10 decimals. That is correct. That is there. Now with regard to 325B, now here the property is 18 decimals, whereas here the property is 11.9 decimals. So how to bifurcate or how to carve out all these? Would that be done here or
No,
before
no,
the
not
executing?
here. I'm just asking you that how
Therefore,
now we are faced with the situation. Now it is for you to tell us how to dispose of this matter. The reason is that you have paid rent to him.
I
That is
paid
the
rent,
point.
but I don't think I have mentioned that I am paying rent for the 34 decimals.
Whatever rent you were paying for the tenanted premises, you paid to him. Whatever rent as per the lease deed you were paying with respect to the tenanted premises to the original owner, you paid to him as per Exhibit 3.
That I'll go through. I'm not sure whether I paid or not.
There is a finding to that effect, and that question of law is not framed. We are not inclined to frame any fresh question.
No. I'll not even ask for it. That is sufficient.
Then you tell us what is the solution to this. Either this particular way in which the document has been exhibited, that has to be nullified, but at the same time a liberty is there for producing additional evidence at any stage. Because that document...
I'll not object to it. Honestly, I'll not object. Only concern is, Your Lordship may see as to why a plaintiff whose entire basis of the suit is he does not even care to file it during entire trial. Only on the date of judgment he goes.
Do we decide second appeals on the basis of intentions?
No, but
in absence of any such finding that there was bad intention?
No, not intention.
So we will not go by the conduct because there is no finding with regard to conduct of one or the other. At least malified conduct is not there. There is no finding to that. आपके पास दो धारी तलवार है. अगर आप बोलेंगे सेल डीड जाएगा, तो वो शेड्यूल भी जाएगा.
नहीं, वो नहीं. I cannot say that entire sale deed. They have a right to lead evidence and all those things are there. But how to carve out which is the portion of out of the total 34 decimals of land? Where is that 24, 21? Whatever they have purchased, who would do it? That is whatever Your Lordship decides. I will not
Total
say.
area दोनों का same. Total area is the same. What is the total area of the property?
34 decimals.
34 decimals was the leased area, and the area purchased by the plaintiff was 21.95, about 10 decimals, 10.25 decimals short of the leased area.
And this should have been actually done by the lower appellate. The lower appellate court does not even care to discuss. Just affirms it, or despite our objections, it just affirms it without discussing it at any point.
Then the lower appellate court ought to have allowed additional evidence on behalf of the parties.
It could have.
It could have had it discussed it, but not considered it completely.
I'll not
This
say
is the
anything.
one line is there.
I'll point out where it is there.
बताइए कहाँ पर?
First,
सोच के बताइए क्या करना है?
First, Your Lordship may see my point A, which there were 3 points which were formulated. Point A, where our argument has been mentioned. No, I see. Para 8, Your Lordship may see. Para 8, but relevant is internal page 7 of the appellate court judgment. From the top second line I am reading. he has further submitted, and that means appellant, has further submitted that the plaintiff claims that it is company but no document regarding registration and provided. He has further submitted that the alleged sale deed by which original owner Bhagwati Prasad Parshuramka had transferred the leasehold property to the plaintiff was not filed by the plaintiff at the time of adducing evidence, and at the time of argument of the defendant, the alleged sale deed was filed, and the learned lower court, without considering the objection of the defendant, marked the certified copy of the sale deed as Exhibit 6 without giving any opportunity to the defendant appellant for rebutting the said Exhibit 6 or to point out the infirmity, and only on this score the impugned judgment is liable to be certified. Now, he has further submitted that the learned lower court committed gross illegality in granting decree with respect to plot number so and so, area 18 decimals, and 326 area 6 decimals, we have further so and so, and then, so this point he does not even formulate for consideration.
You not only paid the rent, but also filed a letter seeking extension of the business.
That I'll have to answer. I don't say that I don't have to answer, but
And the law is well settled, once the rent is paid, rest is not to be.
it has to be established that it was for the entire property. That is what I am saying.
That's right.
If any of the letters shows that I have paid rent for the entire 34 decimals I have mentioned, merely because the rent, let us assume that the rate of rent was.
There is least likelihood of that kind of evidence. The reason is that such plea was never taken in the written statement also. So had it been there that you were paying rent only for a portion of the property to the extent he has purchased, then it would have reflected
So
in
I have
the
denied the entire landlord-tenant
Yes,
relationship.
therefore, but once you pay the rent, how do you deny it? Under law?
So therefore, even
Once you pay
my
the rent, you acknowledge. Simple.
acknowledge with regard to the entire.
We do. Therefore, you have to tell us that you did not acknowledge that was not your case. That was never your case,
I'll
even in the written statement. So if we discard that exhibit is useless for both of you.
I'm not saying about exhibit, I'm just saying that he does not file it at
it
the
is
proper
what-
time. Which
We will say that he has wrongly done it. We will say that it could not have been taken into consideration. Then what is the consequence? We have to see the other materials on record and see whether there is any acknowledgement, there is any payment of rent. If that be so, even if that is not filed, how does that make a difference? That would make no difference. The landlord need not to go and prove his title.
But at least the transfer, I have acknowledged his vendor as my lessor.
ये सब नहीं
So-
होगा तो आप लोग क्या करिएगा और हम भी क्या करेंगे ये बताइए, है ना? बताइए कब करना? कल आप सुन लिए, रिकॉर्ड है यहाँ पर, देखना हो तो देख लेंगे. I'm sure you must be having all the documents.
है.
देखिए सेकेंड अपील नंबर, ये कौन सा नंबर है? ये
Supplementary item 3.
supplementary item 3.
19 of 2019.
19 of 2019. The arguments have commenced. Due to paucity of time, the arguments have remained inconclusive. Post this case for further argument. कल कब?
250.
250? सोच समझ के आइएगा.
हाँ ठीक है.
नेक्स्ट डे के फिक्स करके फिर हम कुछ बोल रहे
बता. कौन सा? हम देखें आपका केस, लाइए दिखाइए इनका केस.
नहीं आप तो देखें, हम जानते हैं आप पढ़े हुए आप लोग.
ऐसा है ना, जब नया बोर्ड आता है थोड़ा टाइम लगता है माइंड को सेटल करने में, प्रिंसिपल्स ऑफ लॉ को करने में.
मेरा इतना ही कहना है कि नेक्स्ट वीक में कोई भी कन्वीनियंट डेट दे दीजिएगा सो दैट इट कैन बी. इट विल हार्डली टेक 15 मिनट्स.
आप भी बताइए ना.
ये
लैप्स का केस नहीं है.
नहीं आप खुद
1894 में आपका एक्विजिशन हुआ अंडर दैट एक्ट. You have filed your
Now only
objection.
question is that
80% आप ले लिए,
नहीं ले
20% के लिए रेफर हुआ, कोर्ट बोला कि ये रेफरेंस गलत है.
He's right, but something is there.
Yes.
इस मामले में हुजूर एक ही जजमेंट है जो 5 जजेस बेंच का इंदौर डेवलपमेंट अथॉरिटी 2020 हम रेफरेंस दे दिए.
अच्छा.
5 किताब हम लिख के दिए.
दिए हैं?
हाँ.
कहाँ है?
उसमें जो 2020 वॉल्यूम 8
हाँ, SCC
पेज नंबर
बताइए.
दिस इज पेज नंबर 129. इस इशू पर सेक्शन 24(2) पर इससे बेस्ट इससे बढ़िया जजमेंट और नहीं. जितना जजमेंट है
क्या
सब
बोला
इसी
गया
को इसमें लैप्स नहीं होगा. दैट इज माय केस.
ठीक है, लैप्स नहीं होगा.
लैप्स नहीं होगा, लेकिन बट देयर इज ए प्रोविजन इन द टेकिंग इनटू कंसिडरेशन दिस एडमिटेड फैक्ट ऑन रिकॉर्ड. 2004 1894 एक्ट में जो अवार्ड बन गया, पेमेंट 80% दिए, 20 आज भी ड्यू है. दैट इज इन फैक्ट. हम 2004 में ही दरखास्त दिए थे सेक्शन 18 में जो पुराना है.
ठीक.
उसमें 13 था ही नहीं. दैट इज एनेक्सर 1.
ठीक.
उसके बाद वो 13 साल चुपचाप पेंडिंग रखती है.
ठीक.
एनेक्सर 2 में 64 में रेफरेंस डीएलओ किया, हम नहीं बोलते
तो गलत किए ना.
गलत किए. उसके बाद बता रहे हैं. उसके बाद छोटा सा हमारे लर्नर फ्रेंड को भी हम बता रहे हैं जो हम एडवांस करेंगे. वो प्रोविजो है उसमें 24(2) का एक प्रोविजो. ये सब उसी को डिस्कस किया जो यही जजमेंट. पैराग्राफ 118
प्रोवाइजो क्या बोलता
118 119 120 इस जजमेंट
क्या बोलता है?
उसमें प्रोविजन में बोलता है कि उनको लैप्स नहीं करेगा, लेकिन ही विल बी पेड. मेजॉरिटी पोर्शन अगर दिया भी है और नहीं मिला है बाकी पोर्शन, तो उस हालत में 2013 एक्ट से इनको कुछ पेमेंट मिलेगी. That is the only thing.
Compensation will be quantified.
But
in terms of 2013 Act.
Yes.
For the entire land or only to the extent
only
of 20%?
Only to the extent to the
Court बोला है that the reference was not maintained. उसको jurisdiction नहीं.
But I cannot be remediless.
Therefore,
if there is no fault on my part,
you will not become remediless.
That is
therefore, the court ought to have
that is my solution.
Have stated that this reference has to go before under the provisions of land
acquisition. That is the only thing which could have been done by the land.
Yes. उसके बाद जहाँ जाता वहाँ आप 2000
हमारा ग्रीवांस
जो भी अपना ग्रीवांस होता वहाँ.
मेरा इतना ही कहना है. I am attacking that judgment only to that extent.
बस हो गया.
I have become remediless.
कल करेंगे. आपको रेमिडिलेस नहीं होंगे. आपका जो भी रेफरेंस यहाँ रेफर हुआ है that will now be referred to the appropriate authority.
तो जो हम 2004 में ही कर चुके थे.
हम जान रहे हैं. तो आपको कॉम्पनसेशन मिलेगा.
हमको बस हमको उससे ज़्यादा कुछ चाहिए नहीं.
यही चाहिए ना.
तो ये कह रहे हैं मुझे, लेकिन जो जजमेंट अंडर अपील है उसको देखा जाएगा.
जजमेंट अंडर अपील में बोलता है कि मेंटेनेबल
नहीं.
हाँ, तो फिर हम लोग होल्ड करेंगे कि मेंटेनेबल नहीं है, लेकिन 20% उनको कहीं से मिलेगा ना.
20% मिलेगा ही.
मिलेगा नहीं. ही इज सीकिंग एनहांसमेंट.
आज 20 साल हो गया.
Seeking enhancement in 2017 he the matter has been referred.
So
मेरा तो सर आप किया है रेफर.
किसकी गलती से?
तो आप रेफर किए हैं. एनेक्सर 2 देखा
2017.
हाँ, तो 2004 का केस अब 2017 में यहाँ पे फाइल हो जाएगा. 2001 में डिसाइड होगा. 50 साल बाद तो लिटिगेंट का गलती है.
लिटिगेंट की गलती नहीं.
हम रेमिडिलेस हो गए.
लेकिन सेक्शन 18 उसको कल
कर देंगे.
कल पर ही
जब सुविधा हो.
इतना ही है कि जो पुराना रेफरेंस था
सेक्शन 18
पुराने एक्ट के तहत उनका वो रेमेडी खत्म नहीं होगा. उनका रेफरेंस जो है हम लोग डायरेक्शन दे देंगे कि उनको रेफर
कंसीडरिंग द लॉ ऑफ लिमिटेशन.
क्योंकि
उसमें लिमिटेशन, क्योंकि ये भी तो 17 में फिर दिए इनको किए.
नहीं हम नहीं किए. तो
17 में किए. 17
एनेक्सर 2 देखा जाए.
पिटीशन क्या देख लिया. पिटीशन जो
एनेक्सर 2 जो पहले देखा जाए जो कौन दिए. जो पिटीशन एनेक्सर 1
जो ये पिटीशन 15/7/17 को दोबारा
नहीं एनेक्सर 1
15/7/17 को दिए. Why did you keep mom for
he is not correct. He is not correct. I am just Annexer 1 is my
50 साल तक केस पेंडिंग रहता है. लिटिगेंट को बोलेंगे
नहीं गलत हो गया. इसको Annexer 1
उसमें
कल बता देंगे.
क्या आवेदन पर एक लिखा अस्वीकृत लिखा हुआ है.
जो भी होगा भाई रेफरेंस भी होगा एज पर लॉ ही होगा.
एज पर लॉ
तो हम उससे बाहर
एज पर लॉ
ही होगा. और ये कह रहे हैं कि हम रेफरेंस किया. आई एम नॉट रेफर. It is annexure 2 by which it has been
जो record है उसका
FA number 196 of 2023. The learned counsel for the appellant has submitted that the land was acquired in this case under the provisions of Land Acquisition Act 1894. Award was prepared and he filed an application in the year 2004 for reference
under section 18.
Under section
18 of the old
18 of the earlier act, of the said act.
in 2004.
Yeah, but the same was not referred, and it was referred only in the year 2017.
by annexure
But the
2.
reference was made under the provisions of 2013
Under section
Act.
64.
Under section 64 of
The
the
Act
2013 Act. The learned counsel submits that the learned court has held that the reference was not maintainable under the 2013 Act, but has not given any further but has not given any remedy to the appellant with respect to his application for reference filed way back in the year 2004. You were seeking enhancement?
Yes.
The learned counsel submits that the
That is the
appellant
requirement.
was seeking enhancement of compensation.
ये
इतना ही
मेडिसी होगा if it has held not maintainable तो इनको ऐसे भी रेमेडी है अगर ये
इतना ही आप बोल देंगे हम लिखा देंगे
अभी हम हम चुप
कल सोच समझ के बोलिए
जो जजमेंट रिलाई कर
he has also submitted that एक second he has also submitted that the litigant cannot suffer on account of the acts and omissions of the concerned authority who had made reference under the 2013 Act instead of making reference under 1890.
In time.
In time. बोलिए.
Delhi was raised at serial number 31. Lordship might order dated 9/8/2024. This court had directed to post this case under the heading of final disposal. I'm just praying your lordship to.
Wrong heading है.
Today it was listed under the heading of hearing.
Just check करिएगा तो wrong heading है. Which I ordered.
Yes, sir. Further, praying your lordship to specify certain date and time.
Final disposal है. फाइनल डिस्पोजल इसको ठीक कर लीजिए. नेक्स्ट वीक में अपने फाइनल डिस्पोजल में आ जाएगा केस ऊपर आ जाएगा. आप उसको टाइम अरे भाई अपने आ जाएगा फाइनल डिस्पोजल में नेक्स्ट वीक में. अब देखिए ये कोड थोड़ा स्लो है हमको समझने में टाइम लगता है, तो यू हैव टू वेट फॉर इट. लेकिन रहेगा फाइनल डिस्पोजल में तो 1-2 दिन में टेकअप हो जाएगी.
बाद में तो जुडिशियल ऑर्डर से हियरिंग में चला गया.
ओह ये जुडिशियल ऑर्डर से फिर हियरिंग में चला गया. आपको कुछ पता ही नहीं है. इट वाज अपलोडेड आल्सो. तो वो कौन बताएगा? वो हम बताएंगे. तो यू आर अवेयर ऑफ दैट. आपको सुन के हुआ था. तो फिर ये ऑर्डर किसने?
I'm just praying your lordship.
ये गलती दोबारा मत करिएगा. कॉस्ट लगा देंगे बहुत ज़्यादा. 4:45 बजे आप जो हैं ये नहीं बता रहे हैं कि ये केस जो है अल्टीमेटली हियरिंग में चला गया.
Issue is very small. Everyone is only without jurisdiction.
अदर साइड कौन है?
Same. Mr. Indrajit Sinha.
उनका कोई है यहाँ पर?
I will inform you.
इसको नेक्स्ट वीक में ना एट द रिक्वेस्ट ऑफ द लर्नड काउंसिल फॉर द देखिए उनके एब्सेंस में हम ऑर्डर नहीं कर सकते. आपको नेक्स्ट वीक आ पाएंगे. नेक्स्ट वीक भी हमारे वीक टू वीक जाता है. यहाँ बिना डेट के कोई केस नहीं. नेक्स्ट वीक हफ्ते रहेगा. उस दिन आप सुबह मेंशन करेंगे, उनको लेके आएंगे, स्लिप में कंसेंट ले लीजिएगा. हम कोई बात नहीं. ये सब थोड़ा सा नया बोर्ड है, हमको लगता है 15-20 मिनट. नहीं जल्दी तो नहीं, लेकिन इट टेक्स इट्स ओन टाइम.